Welcome to the Benefits Executive Roundtable, hosted by Dorothy Cociu, President of Advanced Benefit Consulting. Dorothy is a nationally recognized benefits and compliance consultant and group health broker. Here, you will watch and listen to industry experts who will break down the latest trends in employee benefits, healthcare reform, state and federal legislative and regulatory activities, all designed to empower executive decisions. We are proud to bring to you all new video podcasts. We hope that you enjoy your new video podcast format, and please forgive any audio or video imperfections. Thank you for viewing and listening.
Welcome to the Benefits Executive Roundtable. I'm your host, Dorothy Cociu, President of Advanced Benefit Consulting. And I want to welcome back my guest today, Marilyn Monahan, who is an ERISA and benefits attorney and my friend from Monahan Law Office, and my dear friend Ann Kelly, who is a producer for Patrick and Patrick Insurance Services. And I've known both of you for decades. And I just want to say thank you very much for being with me today. What we're going to talk about today is some tips and tricks to help you to get through this last 8 weeks of our very, very busy open enrollment season. This podcast will air on November 4th, and that will be the last 8 weeks of this season. So thanks a lot for being with me here today, you guys. I really appreciate it.
It's a pleasure. It's always a pleasure.
Hello, everybody, and I'm hoping today we can give you some pointers that will save a lot of time. A stitch in time saves 9. So hopefully we're going to give you plenty of stitches so that you can get through this Q4 as easy as possible with as few glitches as possible.
That's the whole point of tips and tricks, right? That's what we want to accomplish today. Well, I thought it would be a good idea to summarize and remind everyone of, again, those tips and tricks, but also some compliance tasks that you want to make sure that you complete within your open enrollment season, and with making sure your packets are properly done and so forth, whether they're electronic or whether they're paper. And this last 8 weeks is crazy time for everybody. So again, we just want to help people get organized, stay on track for what they're supposed to do, and, share some information that maybe could help them be more organized through this last 8 weeks. So as you guys know, I recently wrote an article for the County of Orange Insurance News for the November-December issue, and it was basically on this topic, tips and tricks for getting through the open enrollment season, right? So I asked you guys to contribute to that article, and I appreciate it very much. But those comments that you shared for the article, I thought were very interesting. So I thought, why not have a podcast on this same topic? Because I think a lot of people will be struggling getting through, again, that last 8 weeks. So let's get into this. There's a lot of things I want to cover today. So Ann, what are a few things that you do as an agent to stay organized and get ready for your clients' requests? Because we know there are lots of them this time of year.
It's absolutely crazy this time of the year, particularly since after the Obamacare regs came in 2014, a lot of groups changed their open enrollment to December 1st, particularly in the small group market in California, which is your 1 to 100 lives, to avoid going into ACA plans. That being said, it's created havoc in our industry. We also have the marketplace open enrollment going on, and we have Medicare open enrollment going on. So there's a lot of movement in the market. So the best answer really is to be well prepared. A stitch in time saves 9. And my number one advice is have an established written protocol for every different stage that you have going into Q4 and open enrollment for 2025. Starting with analyze all your groups, have your list of groups, who you need to quote, who you don't need to quote for, and gathering all the necessary data well ahead of time so that you're prepared going into open enrollment season. That's step one. We'll talk about the other steps later.
Okay. And Marilyn, what about you? I'm sure that you're flooded with all kinds of questions at this time of year, particularly compliance questions, disclosure questions. What do we absolutely need to do? What do we have to do during open enrollment season? Would you care to comment on that?
Well, I'd say 3 key things that you need to do is the employer needs to make the decisions leading up to open enrollment season as to what benefits they're going to offer and what the employee contributions are going to be and whether or not they're going to be affordable if the employer is an applicable large employer. We can talk a little bit more about that. The other thing is making certain that you're giving an offer of coverage to everyone who's eligible and that you're documenting that. And the last thing is making sure you're distributing all the documentation that ERISA or any other benefit law requires so that participants and beneficiaries have that information available to them so that they can make decisions about what they want to elect, as well as once they do elect, they know what the terms and conditions of their benefits are.
Okay, great. Thank you very much. Let's start with the basics, as you mentioned. Let's start with ERISA compliance and required disclosures, the basics, as we like to call it. What is the most forgotten or skipped over requirement, do you think, that plan sponsors aren't doing or their agents aren't reminding them to do during open enrollment?
The one document I see that employers are most likely to omit is the plan document. And I think that's partly because you don't have to distribute the plan document at open enrollment, but it is a necessary legal document required by ERISA. So you do need to have it in case a participant or the Department of Labor ask for a copy of it.
Right, for sure. Anne, what has your experience been? What do you think your clients are forgetting to do and probably wouldn't do if they didn't have your assistance?
That's actually most overlooked by both clients and insurance agents, the plan doc. And I would probably add, and I think Marilyn will probably talk to this later in this morning's podcast, a wrap document can save a lot of headaches. So that's hard for agents who haven't done it before or haven't paid attention to it before. But when things slow down, if you don't have time to do it now, I definitely suggest moving into 2026 that you look at creating wrap docs for all your clients. There's a lot of TPA services that will actually create those and handle those for your client base.
Right.
I think that's an excellent point, and that was going to be something else I was hoping we'd get around to talking about today, the wrap document. It's absolutely essential, whether you've got a fully insured plan or a self-funded plan, you need a wrap document or the equivalent of one. Just as an example, a lot of carrier EOCs won't have full eligibility provisions in them. They won't talk about a waiting period, but you have to communicate that in writing, and the wrap document is the vehicle for that. So
Right.
I would encourage brokers and employers to put in place wrap documents and then to distribute them at open enrollment time.
Right. Thank you very much. Marilyn, I also want to ask you, you both talked about the importance of a plan document, but that's basically written in what we call the language of lawyers, right? So what's the difference between a plan document and an SPD, a summary plan description, in simple terms?
Even the U.S. Supreme Court calls it a document written in the language of lawyers. So the plan document is the legal document that establishes and maintains the plan, but it's not a very effective communication device because it is written in the language of lawyers, typically, a lot of legalese. So what you need in addition to the plan document is what they call a summary plan description, or SPD. And the meaning is in the name. It's a summary plan description, a summary of the plan terms. So what you technically do is you take the plan document and you convert it into language to be easily understood by the average plan participant. And that's what you distribute.
Thank you very much. And in the event of an audit, Marilyn, the plan document, as of course you and I have seen many times, is usually the number one or number two thing that the Department of Labor auditors are going to ask for, their list of items that they're going to ask you to have in place or in front of them when they show up. What does the plan document need to have in it?
Well, technically, there are a list of items written in to ERISA, part of the ERISA statute that says you have to include in the plan document. You have to identify the plan fiduciaries. You have to have a procedure for establishing and carrying out a funding policy. You have to have a description of any procedures the plan has for the allocation of responsibility with respect to the operation and administration of the plan. You have to have a procedure for amending the plan, and you have to have the basis on which payments are made to and from the plan. So you need all those elements. There's additional elements you're going to need. Obviously, operating a plan is a complex task, but those are the key elements that ERISA will expect. And as you can tell from my description, those are not going to be found in the carrier's documentation. Right. So that's why you need a wrap to add those additional terms.
Right, exactly. And as you said, the SPD, which is the primary method of describing the benefits to the participants in a way that they can understand it, that has to be easily understood, as you mentioned. And they talk about, in ERISA, it must be in clear, simple communication. What does that really mean?
Well, it should be written in language that's easily accessible and easily understood. And another key part of it is it should be structured so that key terms are easy to be found. So they actually have format rules, whereas, for example, you can't put exclusions in 2-point type and the benefits in 14-point type. They don't want you to hide things. They don't want you to put a term in a section of the document no one would think to look at. The courts actually look at how the document is structured, what things are put in bold, what things are underlined. So again, to repeat, the key issue here is clear and concise communication so employees, participants, beneficiaries can find the information they need and really understand what the terms and conditions of the plan are.
Right. And in addition to that, what must be, you mentioned some of it, but what are the specific items that need to be included in the SPD that you haven't talked about yet?
Well, they have a whole set of content rules, and a lot of these terms, if you've got a fully insured plan, will be contained in the carrier's evidence of coverage. You know, what the network is, what the plan limits are, what's covered, what's excluded, etc. All essential terms that will be in the carrier's documentation. But there are a few extra things that ERISA requires that won't be in carrier's documentation, such as specific eligibility terms, such as you must work 30 hours per week in order to be eligible. The carrier document will not have waiting periods. Plan name, these are things that you'll find in the Form 5500 if you're large enough to file that. The plan name, the plan number, like Plan 501, the name of the employer, and the contact information. Those additional items need to be provided, and they're not by the carrier. So that's, again, information that you include in the wrap document, and then you distribute at open enrollment, the wrap document plus the carrier's documentation, and the entire package becomes your SPD.
Thank you for that. And Anne, and you guys both mentioned the wrap document earlier, but I want to come back to it, and I want to ask Anne specifically. Do you think that most fully insured employers, plan sponsors have a wrap document?
No, the majority do not. And definitely when insurance agents are helping them with that, a wrap doc saves you having to have different docs for each underlying plan. It basically wraps all your different insurance plans together under the one document. On a side note, Dorothy and Marilyn, the Department of Labour has some wonderful material on their website. And this particular one is reporting and disclosure guides for employee benefit plans. For agents that are listening or employers that are listening, it's a good idea to get onto the Department of Labour's website and pull down those disclosure reports. It talks about your summary plan description, summary of material modifications, your summary annual report, your plan documents, the type of information that it contains, to whom and when it needs to be distributed. So it's a nice little guide to have in your office as an insurance agent, and also to hand to a client when you're sitting with them and talking about their compliance issues or doing a compliance audit. That way you're leaving behind something and the client then trusts the information that you have given them.
Right. And Marilyn and I actually discuss that a lot when we do compliance webinars and seminars. We talk about, particularly the ERISA seminars and webinars that we do. We use that as kind of a very important government provided piece and it's also very attractive. And, it's like purple or something like that, kind of a purple color or something like that. So if you're printing on color paper, be advised that it's going to take a lot of color ink, and it's very dark, right? So the backgrounds, but it's very, very helpful. And we refer to that all the time. Marilyn, is there anything that you want to add to that?
No, I think Anne summarized the issues quite well.
Okay, good. Well, then let's move on. Let's talk about another open enrollment requirement, the SBC. Marilyn, you and I have already done a few discussions on this, a few webinars and seminars and so forth on updates this fall. And the one, in fact, we did one just yesterday as we're recording this with my own clients and some of Anne's clients as well and others. It was on the One Big Beautiful Bill as well as legislative updates. And at the end, we did the legislative updates and we talked about the new information that came out from the departments on SBCs. Now, what happened kind of took us all by surprise. What happened at the end of September that kind of changed related to the 2025 requirements for SBCs?
Well, there's been a new requirement starting in 2025, the beginning of your plan year in 2025. You have to have taglines in 8 different languages. It used to be 4. They've added 4 more beginning in 2025. So they provided us with the translated taglines in advance, but they did not provide updated templates until September 30th when they just posted them on their website without any advance information, announcements, or disclosures. So they now have amended English language templates with the 8 taglines, plus they have templates translated not only in the 4 original non-English languages, but the 4 additional. So you've got an updated English language template with 8 taglines in 8 different languages, and then you have templates translated into the 8 different languages.
And I know we could talk about this for quite a while, but just for information for the audience, basically you only have to provide those if you happen to have plan participants residing in the counties in which they're required in that class document that came out a couple of years back. It's listed county by county, so you can look at that, see where your employees are located, and make sure that no one is above 10% for that language. And here in Southern California, the most common obviously is Spanish, and that's for Southern California, Los Angeles, Riverside, and San Bernardino counties. You have to have a Spanish translated SBC. And in Northern California, Chinese, right, in San Francisco. So you have to look county by county for your population. And by the way, they did not make it easy. When you told me they were there, I couldn't find them on the website. As I told them, like, I can't find them. I had to keep digging deeper and deeper and deeper down in there till I finally found them. Then I created a Dropbox folder for my clients and so forth and said, you have access to this so you can pull them all down, because trying to find them on that was not an easy thing to do. So anyway, they're out there. And by the way, if your renewal date was March 1st or August 1st or September 1st and you had the old SBCs, guess what? You kind of need to go back and redo those for particularly if you're a self-funded client, because this is a requirement for plan years in 2020, starting in 2025. So that means for my self-funded clients, I had to go back and redo their SBCs for their 2025 renewals, which was kind of an interesting thing.
So I'll add 2 points to that. And one is that following up on the fact that they're not easy to find, they also have the old versions still floating around on the CMS website. So make sure you use the most recent version. And the easy way to do that is just to make sure there are 8 taglines versus 4.
Right.
The other thing that I would say is if you've got a fully insured plan, your carrier will take care of updating the SBCs. This is really more of a challenge for self-funded plans where you're going to have to update your SBCs and work with your TPA or administrator to make that happen.
Or me.
Or
Dorothy. That's different for our clients. So yeah, for sure. And question for you, and I don't mean to put you on the spot, but before we were talking about this, were you even aware that there were new requirements for SBCs? Because
I was, because I was at your compliance seminar, Dorothy and Marilyn. You do always keep us
I
up
meant
to date.
before.
Yeah. But that being said, like for the majority of agents, you do your best, you know, and if you have a client with a heavy international speaking language, just make sure that you're putting stuff out in their language. It doesn't have to be that complex. Obviously, Dorothy is dealing in self-funded. She's having to create these docs. Your carriers create them. One of the things I prefer to use when we use Ease system and Rippling, and we will be going to Navigator. They have a benefit comparison on the medical's Excel spreadsheet that the employees can review. But underneath each plan, the carriers automatically bring in the SBC, make sure that that's a required read, because the system will log that the employee opened it before they could sign off on their benefits, and it keeps a tag on that. Otherwise, the Excel spreadsheet works way better.
That's not what the government requires, though. The government requires
exactly,
the SBC.
But last year, Employee Navigator, which is going to be taking over most of California, did not have the availability to Excel spreadsheet the plans. And I had to sit the owner down and tell him that we have multiple plans in California that the employees can pick and choose from. We use the example of California Choice, which is a bucket of different carriers, and that the having to read all of the SBCs with an employee to cover the differences in plans would be outrageous, so that he needed that quick push button Excel spreadsheet. If you're not using a system like that as agents, it would be nice if you did spreadsheet on an Excel, the plan comparison and rates, and make it simple for the employees. And at the same time, if you're not using an online system that has the SBCs automatically built in, make sure you are distributing those as well.
And keep in mind, the carriers probably didn't make a big deal of it. I don't think. I know we do have some fully insured clients, and they didn't make a big deal of the fact that these new SBCs are even available. So sometimes you have to ask for them or go onto their websites and find them. And again, if agents didn't know they were supposed to do that, because again, it was a pretty non-event, right? On September 30th, they didn't really there wasn't a lot of big hoopla about this. They just released these things and it was like, okay, here they are. So anyway, we need to move on. But before we do that, we're going to take a quick commercial break. And when we come back, we're going to talk more about mandatory notices, the ACA rules, some concerns with the One Big Beautiful Bill, and some other items. We'll be right back.
Meet Advanced Benefit Consulting, an award-winning boutique benefits broker and compliance consulting firm that offers comprehensive benefits and compliance consulting. We offer personalized service and the ability to work directly with the owners. We invite you to contact us or connect with us on LinkedIn and include us in your broker consultant search. Marilyn Monahan of the Monahan Law Office counsels employers and producers on compliance obligations under federal and state benefit and insurance laws. If you have questions about ERISA, COBRA, HIPAA, and the ACA, the Monahan Law Office will help you navigate the legal requirements that apply to you.
All right, welcome back, everyone. Now, let's get on with this. We still have a lot of information that we want to cover. Let's talk about mandatory notices and open enrollment checklists of materials. Marilyn, can you briefly tell our audience what notices need to be in the open enrollment materials?
You need to distribute the SPD, which is going to be made up of the wrap document, the carrier's evidences of coverage, plus a contribution schedule and any other essential terms. For the major medical plan, you're going to need to distribute the SBC, and failure to distribute the SBC is a particularly expensive failure if the Department of Labor were to penalize you for that. There are also some annual notices that must be distributed every year. The Women's Health and Cancer Rights Act notice, the CHIP notice, and the Medicare Part D creditable and non-creditable coverage notice. The Women's Health and Cancer Rights Act notice might be in the carrier's EOC. If it's not, it can be added through the wrap. The CHIP and the Medicare Part D are standalone notices, which can be included in the same package, but as a separately identifiable document so that it doesn't get lost in the other verbiage in those documents. And then there are some other notices that don't necessarily have to be provided on an annual basis, but I think most of us think it's a good idea to provide them on an annual basis and include them in with the SPD and the other documents, such as the HIPAA notice, special enrollment rights, the Newborns and Mothers Health Protection Act, Michelle's Law notice, a grandfathered notice if your plan is grandfathered, the notice of patient protections, the initial COBRA notice, and the HIPAA notice of privacy practices, which we may talk about a little bit more.
Plan sponsor employers are required to distribute this information once they're prepared, and there are specific ERISA distribution rules for the SBC, for the SPD, for mandatory notices, and so forth. Marilyn, can you tell us a little bit about the ERISA distribution rules?
The ERISA distribution rules are designed to ensure actual receipt. So they have different methodologies you can use. You can use in person and hand them to all your employees directly. You can't just put a stack in the break room. You have to hand them to them at an open enrollment meeting. Get a sign-in sheet so you know that the people were there. You can mail them versus via first-class mail, and that's an excellent way to get things out to COBRA qualified beneficiaries, people out on leave, maybe even people teleworking. And then you can distribute electronically. But electronic distribution is a little bit trickier than you might think. The key here is whether or not you need consent in order to distribute electronically. You don't need consent if your employees are actively working on the employer's electronic information system on a daily basis. So if they've got an email address, they've got a laptop, they've got a desktop, and they're working on the computer all day long, you can send them an email flagging the importance of the document and distribute notice that it's open enrollment time, follow the link here. And that's acceptable. But for those employees, for example, production employees, warehouse employees, people who aren't actively working on the employer's computer system, you either need to use one of the other methodologies like in-person distribution, or you need their consent in order to distribute electronically. The reason this is kind of convoluted is because the ERISA electronic distribution rules were issued in 2002, which was, I mean, that's the dark ages as far as electronics go. So that's before smartphones. And so they need to update those. But until they do, we're kind of stuck with the old system.
Right, right.
And I know you've done this, Dorothy, for your clients, is get all your notices and put them in one compliance manual if you can. And that way it's easier to distribute both in your online system, you know, with the Employee Navigator or Ease, there's a notices section and you can just throw all your notices there in one clear doc with an outline as to what it contains. And the employees have access year round, both on their computer as well as their telephones, as Marilyn said. We're in a modern age. They can access those year round. Making sure, it's one thing to have the notices there, but it's another thing to make sure that some of those notices you're particularly paying attention to. And I would emphasize the Medicare credible coverage notice, Marilyn, because a lot of agents are now putting in bronze level high deductible health plans that may not be credible coverage for Medicare, and that's a problem. So check your plans and actually make sure that what you're doing with that group, that the plans you're offering are credible coverage. And if they're not, that you've got a notice as to that to the employees, because that's a lawsuit waiting to happen.
Yeah.
I agree with that advice.
And those rules were updated last year, so people may not be aware of that. So I just recently interviewed Maggie Stead on, the changes to Medicare, and we really hit home on that quite a bit, because it's like people may not realize that these notices have changed, that you may not qualify. You've qualified for credible coverage in the past, and you may not qualify for credible coverage in the future. And you need to have ample opportunity for the employees to know that, oops, I need to sign up for Medicare and get on a Part D plan because my employer plan is no longer credible and I need to have that coverage. So yeah, that's very, very important. Thanks for bringing that up. I do want to move on to some other topics. And I asked you this for my article, and thank you for contributing to that, by the way. What are the most common compliance questions that your clients are asking you during this open enrollment season?
So probably for the majority of employers, and particularly those that have to be ACA compliant, the biggest thing is setting their affordability measure to make sure that the lowest cost plan that they're offering is offered to 95% or more of their employees at an affordable rate. So that would be the number one issue, because that carries severe penalties.
Yeah. And Marilyn, are there certain things that you see there that you would want to comment on?
I'm going to reiterate what Anne said. I think that's the most common question and inquiry I get is about offering the right coverage to the right people at an affordable rate and how to make that determination. And the second item is what we've been talking about today, which is what documents do I have to distribute and how do I have to distribute them?
Right.
I think those are the two key areas of compliance that I hear most about this time of year.
Right. Thank you for that. Now, there's a difference between what's affordable to the employees and plan participants and what's affordable under the ACA requirements. Would you like to comment, either of you, on that difference?
Well, affordability is a term of art under the Affordable Care Act, and there's methodologies that you can use, 3 in particular, in order to make certain that the amount you're asking employees to contribute for self-only coverage toward the lowest cost plan satisfies the ACA's affordability standard. But that amount may not seem affordable to your employees. It may seem too high for some of your employees, and they may be reluctant to sign up. So the employers have to do a balancing act every year, and they have to, if they're an applicable large employer, they're going to want to make certain they meet the ACA affordability standard. But the next step is how many of their employees will feel comfortable paying that amount. And if they're trying to maximize enrollment, do they need to make some adjustments to make it even more cost effective for their employees?
Right. So let me ask you this. Besides the ACA, what are some other common questions that we're getting on compliance this year?
Well, as we talked about earlier, I think the documentation. What do I have to distribute and how do I have to distribute it? We're also getting some questions about changes in the law and whether or not they're impacting particular employers' plans. There have been some changes in state law that impact fully insured plans, such as the new mandate for large group health plans to cover fertility and infertility benefits. And then we're getting questions about the One Big Beautiful Bill and what does it mean? And as an employer, do I have to make changes accordingly? Do I have to update my SPD? What are my options? What are the mandates?
Right, right. Well, thank you for that. And we're going to talk more about the One Big Beautiful Bill in just a moment. So one of the things that you and I have talked about, Marilyn, in our webinars and seminars recently on the One Big Beautiful Bill, and Anne, you've been obviously present during some of those discussions as well, are the premium tax credits and the exchange. Those are scheduled to go away at the end of this year. And obviously that's one of the primary reasons why the government is shut down, at least as of the date we're recording this podcast. The government is still in a shutdown mode. So let's talk about this for a moment. You and I, Marilyn, have said this, that we feel that there are going to be fewer people enrolling in the marketplace coverages because they're not going to be eligible for premium tax credits. So what does this really mean to an employer? What should they be worried about in the event that this will happen? It's likely to happen.
Well, under the Affordable Care Act, individuals who go and buy an individual policy from the federal marketplace or a state marketplace like Covered California might be eligible for a premium tax credit, which helps offset some of the premium costs that would otherwise apply. And those have always been based on income. Now, during the pandemic, they passed some legislation to expand and extend the premium tax credits. So a lot more people have qualified for them. And as a result, millions of Americans signed up for individual coverage through the marketplaces, expecting these premium tax credits because it was a lot more affordable for them. Those expanded premium tax credits expire at the end of 2025. And so that means that in the new year, not only are individuals who buy individual policies from the marketplaces going to be looking at premium increases, they're going to be looking at, for many of them, a loss of those premium tax credits. So it's a bit of a double whammy. They are anticipating that millions of people will drop off of coverage as a result. So that is one of the issues that is being debated right as we speak, as we're recording this podcast in Congress, related to the shutdown, this as well as some changes that were made in the Medicaid program as a result of the One Big Beautiful Bill. It could have an impact on employers, even though we're talking about individual policies, because it could mean that more employees and their family members could turn to the employer and look for coverage options. It could also mean, let's say someone is eligible for COBRA because they are terminated or they have a reduction in hours. It could mean more people will sign up for COBRA as opposed to signing up for a marketplace coverage because the marketplace coverage won't be as affordable as it used to be. That could also lead to adverse selection because the people most likely to sign up are the people who are most likely to have larger health claims. So there's going to be potentially a trickle-down effect to employers in 2026 and in future years as a result of the loss of the premium tax credits as well as the Medicaid changes created by the One Big Beautiful Bill.
Thank you for that. And I'm just going to ask you this. Do you think it's important for agents as they're finishing up this last 8 weeks or so of open enrollment for the end of the 2025 fourth quarter here? Do you think it's important that they perhaps in open enrollment meetings discuss and mention to the plan participants as they're having their open enrollment meetings that, hey guys, just so you know, the premium tax credits are going away. Just as a reminder, they're going away at the end of this year. Is that something that you think that maybe agents should discuss with their employer clients and maybe with the employees in open enrollment meetings?
Absolutely, Dorothy. I was talking actually with our individual rep that does the marketplace insurance, and they're seeing 30 to 40% price increases in addition to the subsidies going away. That's what people are seeing. So it's coming in hard and heavy already. Yeah. So for agents out there, pay attention to that. You don't want people last minute scrambling after their open enrollment day trying to get their spouse or dependents or themselves on the employer's insurance. We should preempt that now and get notices out to employees so that if they are in a small group where they're not offered an affordable plan, that they are aware that the marketplace is showing huge rate increases, that the subsidies are going away, and please make sure to review ahead of time your employer's offering. Or if you have your insurance through your employer and they're a large group but your dependents are on an exchange plan, be aware that they're seeing very heavy rate increases because of the Great Big Beautiful Bill, and that the employer's plan may suddenly become much more affordable. And just as a reminder, anything you do through your employer's plan, if you have a premium only plan there, is pre-taxed through payroll. And for the majority of employees, that's a 30% rate decrease because their taxes are dropping the equivalent of 30% on their share of premiums.
Yeah, and one thing I want to mention too, related to that, one of the things that Marilyn and I have talked about in webinars and seminars that we're doing on this topic is the fact that employers should also be concerned with perhaps people enrolling in COBRA again, because people weren't enrolling in COBRA. They wouldn't, when they terminated their coverage, they went on to the exchange because it was cheaper for them because they could get, in many cases, a subsidy, right? Particularly if they lost their job or something. And so they went on COBRA. That's something that employers need to think about too, especially if they're self-funded, right, Marilyn? Because that could be an unexpected additional cost to them as well, because if they're self-funded, they're going to continue to pay for that person on COBRA during the entire COBRA period, correct?
And that's not to mention the Medicaid issue now with the Great Big Beautiful Bill. I'm sure
we'll come back to them. I just want Marilyn to answer this question, then I'll come back. I do want to discuss the Medicaid situation, but Marilyn, did you want to comment on the COBRA situation with employers?
I think that's absolutely the case. In the last few years in particular, we've been reminding employers to update their COBRA notices and to talk to their employees about looking at marketplace options in lieu of signing up for COBRA because they might find it more affordable. That may no longer be the case, and they believe that COBRA is really their best option. And that could, as I said earlier, lead to adverse selection because you're more likely to get people with the higher health claims signing up for COBRA.
Sick people sign up for COBRA. Healthy people generally do not. And I want to come back because you mentioned it, and I was planning on asking this and asking you guys this question anyway, and I want to come back to it because it's a very important part of the One Big Beautiful Bill, and that is the provisions within the One Big Beautiful Bill that affect Medicaid and Medi-Cal here in California. Fewer people are going to qualify, as we mentioned, for premium tax credits. They're going to be going away. So unless it's extended with through the rest of the government shutdown, if they come back and say, okay, we're going to go ahead and extend them or whatever, but we're going to assume at this point that they're not. Let's talk about the changes within Medicaid very briefly because we're just about out of time here. Medicaid and Medi-Cal. Marilyn, you want to just fill in our audience briefly on what's going on there?
The One Big Beautiful Bill contains a number of provisions that are going to impact Medicaid or Medi-Cal in California, and they are being implemented over time, not all of them right away. But some of the major changes are the work requirement. They're going to be adding co-pays for certain individuals. They're tightening up the eligibility rules so that people have to provide additional documentation in order to establish their right to the coverage, etc. Similar to the changes we talked about with regard to the marketplaces and the loss of the expanded premium tax credits, we're also going to see changes in the Medicaid situation. We're going to see fewer people covered under Medicaid, and that's going to have a similar impact. If fewer people are covered, they're not going to be able to get health care. Providers aren't going to be able to be reimbursed for services, or they're not going to be able to provide services at all. More people will be sicker. That means they'll show up at emergency rooms. Providers will have to treat them at the emergency rooms, but then they'll have to look for a way to get reimbursed for that. That could cause an impact on the commercial market by causing prices to go up, and that's both for fully insured and self-funded. So again, we're looking at a trickle-down effect on employer plans. Yeah. You might think, what does Medicaid have to do with me? I'm an employer, but it does affect the marketplace overall, and ultimately employers could feel the effect of the loss of the Medicaid reimbursements.
And I just want to throw one more thing in, just because it came up. We had providers on our webinar yesterday, and I knew this would come up, and we talked about it. It was in our slides anyway, but it's important also for people to understand that emergency Medi-Cal or emergency Medicaid, depending on where you're located, provision that allowed you to go retroactive to get Medi-Cal or Medicaid 90 days. That's changing to 30 days. So because one of the providers, like, how are we going to get paid? What do we need to know? And I explained to them that you're going to need to make sure that your employees that are dealing with this in intake and so forth, that they know that this has been changed to a 30-day for emergency Medi-Cal or Medicaid and not 90 days. So make sure that they're educated on this so that they can move on this quickly. Because if you've got somebody that's going in the hospital that doesn't have coverage, and then before they would just apply for Medicaid and get it, or Medi-Cal, that's not going to be as easy as it used to be. So I just wanted to mention that as well. But we do need to move on. I have one final question here. We talked about this briefly earlier. We talked about HIPAA privacy notices and HIPAA privacy rules and so forth, and the changes there. One of the changes that's coming up in February is the new notice of privacy practices, and those are not required annually. Those are required at least every 3 years unless there are changes. But Marilyn, can you just fill our audience in on what's going to be changing as of February? We don't have the new model notices yet, but what's going to be happening in February that's effective in February of 2026 related to notice of privacy practices?
Well, people are going to have to send out new notices of privacy practices. So this is going to impact insurance companies as well as employers with self-funded plans. And when I say self-funded plans, I also mean health FSAs and health reimbursement arrangements. So don't forget about that. Originally, we believed that the Notice of Privacy Practices was going to have to be amended to reflect new regulations under HIPAA related to reproductive health care, as well as a separate set of regulations related to substance abuse records. A court put a hold on the HIPAA reproductive health care regulations, so you no longer, or at least as we sit here today, have to amend your Notice of Privacy Practices to reflect those changes, but you still need to amend it to reflect that other set of regulations regarding substance abuse. So you do have to send out a new Notice of Privacy Practices in February. The government has said that they are going to issue new model notices. We haven't seen them yet. If they don't, the requirement will still be in place.
Right. Well, thank you very much for that. We're about out of time here. So just as a closing here, what can people do what are your recommendations to de-stress a little bit during this last 8 weeks of open enrollment?
Dorothy, you don't want to ask me that because mine is a margarita at the end of the day.
I would say
for
find something.
For purposes, it works quite well.
I would say find your happy place, whatever it may be.
Yeah. I get
Find
it.
something to binge on a streaming service. Find a good book to read. Find a good way to kind of take a walk, find a good way to lose yourself.
Watch the
for a
World
few minutes.
Series, watch a hockey game, watch whatever. For me,
All those things work.
Yeah,
that's how I do
but
it.
we are going to see a huge influx back into the employer group market of people coming off Medicaid and Medi-Cal in California and coming off the covered Cal subsidies. It's going to be gigantic. So be prepared and try and get out in advance of that with your employer groups so that you're not scrambling at last minute trying to compensate for people losing coverage through the exchange at the 12th hour.
I'd like to reiterate what Anne just said. And don't forget, your employees may already be on the plan, but it could also be their family members who are losing coverage through Medicaid and the marketplaces who will start looking for coverage and will be turning to employers to get that coverage.
Right. Yes, for sure. Well, thanks for all this great information. I wish we had more time. There are a lot of additional things we could talk about, certainly within the One Big Beautiful Bill and others. Marilyn and I have already done a podcast on the One Big Beautiful Bill. So, hopefully we covered all that stuff there. But I want to thank you for all this great information. If anyone should want to reach out to you, how would they do that, Marilyn?
My email address is marilyn@monahanlawoffice.com.
Anne?
Anne at patrickinsuranceservices.com.
Thank you very, very much. And thanks again to both of you for being with me here today. I really, really, really appreciate you.
My pleasure.
Goodbye.
Well, thanks again, you guys. I really appreciate your being here. And for those that are watching and listening, thank you very much for watching and listening to the Benefits Executive Roundtable. We're going to be taking a break for the holiday season, as we always do. So I do want to wish you all a very, very happy and safe holiday season. And we will see you in January of 2026. So for all of you, please stay safe, stay healthy, and stay tuned for the next episode of the Benefits Executive Roundtable in 2026. Thanks, everyone.
Thanks for watching. Stay tuned for compliance tips, cost containment ideas, new trends, and decision-making tools. This podcast is produced by Advanced Benefit Consulting, Fullerton, California. All views expressed are those of the host or interviewees and not necessarily those of Advanced Benefit Consulting. Information contained herein should not be construed as legal advice. We always recommend that you consult with your legal counsel as situations do vary. Ms. Cociu can be reached at 714-693-9754 extension 102 or toll free at 866-658-3835. By email at dmcociu@advancedbenefitconsulting.com or visit our website at advancedbenefitconsulting.com.